Good evening. Captain Retired Matt Edwards here with the next installment of the Observation Post weekly Facebook Live broadcast. Gonna do what I did last week, and I'm just gonna read off the main post that I put out today. Lately I've been putting out about one post a day, and I'm trying to keep it a bit short, but I find it hard to keep things short. So here, and the other thing I might do I'm going to try to keep it less than 35 minutes. So I'm going to try to, if I finish up quick enough, to go through a letter I started up to the lawyers that I hope to start, searching for soon. So anyway, 23rd of May, 2024 Observation Post 1. Number 1, the Bradburn rule reversed. A. In the common law, insurance and pensions are not allowed to be clawed back or to reduce damages meant to make the injured party whole. Since at least 1875, when the Bradburn versus Great Western Rail Company was decided in the United Kingdom. See attachment. It was phrased as he was entitled to full damages as well as the payment from the insurer. Now, the man had a £30 insurance. He was a policeman. He became injured. And the people at the railway tried to say, well, he was made whole by the insurance payment, so therefore we don't have to pay any damages. They failed. Now, the judge was mostly saying that it was a contract instead of tort, so it was a different field of law. So he was entitled to get both. So the compensation for the injury made him whole, and the insurance payment didn't compensate him at all. B. In Canada, this rule applies as well. So what I'm trying to do here is go down through it logically. A, B, C, and all of that adding up. C. Accordingly, the Pension Act of 1919, pension as a replacement for tort damages, did not claw back the Service Income Support Insurance Plan, Policy 901-102. Since 1969, when the non-indemnity and contributory contractual insurance was begun. Now that's an important point. They didn't even try to take SISIP into account because it was against the common law. D. However, in 1976, the government decided to allow the pension plus SISIP as the pension award was not enough income to live on. Then somebody reversed Bradburn and did the opposite, clawing back the indemnity for injury meant to make someone hurt in service whole. It's travesty. You shouldn't be trying to use a non-indemnity payment to take the indemnity into account. Idiots and crooks. E. This was reversed in contract law in 2012 when Dennis Manouge versus the Crown was decided in the veteran's favor. However, the court made a drastic mistake, saying that the SISIP long-term disability insurance is a replacement for tort damages, and the pension was for pain and suffering, which is another form of compensation. It is accepted as being non-economic in the non-economic head of damages. F. A year prior to Manouge's Federal Court 2012 being started, there was a case in British Columbia which stated that the Bradburn rule was still in effect in Canada, as the Royal Canadian Mounted Police Great West Life Insurance was not clawed back from the tort damages, as it was non-indemnity, which I put in brackets is not compensating for loss, and contributory. Two aspects are important. Number one, non-indemnity means the payment was not does not violate the compensation principle of tort law, as the only indemnity for loss, as indemnity for loss counts as compensation for loss, and the other payment is not double compensation. 2. Let me see. I put this in mathematical terms, so forget 2 for now. I put this in mathematical terms as compensation equals 1 and non-compensation equals 0. So 1 plus 0 equals 1. There is no double compensation. And point number 2, contributory means the person bought the insurance or pension with the time and money, with time and or money. So there is no equitable principle which would allow the wrongdoer to save on damage because the victim had insurance or a pension. Then I put in brackets my reference for that. Even if I'm not a lawyer, I can read. Botarelli versus Flanagan, Ontario Court of Appeal, 1973, stated that there is no equitable principle that would allow a person who wronged another to save at their expense because they have earned benefits. Okay. G. However, the system had other cases where the wrongdoer or the wrongdoer's insurance wanted to save money on tort damages or long-term disability insurance. The first example, or 1, I guess you could say, it's a Roman numeral. Gibson, Ontario Superior Court, 1984. The Crown, through Sun Life Policy 12,500G, introduced the insane idea of partial compensation for loss of income. I say insane because tort damages are not about income, and then I put in quotes the brackets, the Andrews versus Grandin Toy Supreme Court of Canada case in 1978. A capital amount has been lost when you have been injured, so a capital amount is to be paid to replace the capital loss. Apples for apples. Number 2, Ontario in the 1980s tried to do away with Bradburn in the field of car insurance. So to many people, if you get a compensation payment in tort and you get long-term disability insurance in contract, to them it appears that you've been paid twice. So they figure this is unfair, that you get compensated twice. They don't take into account the 1 plus the 0 thing. 3, Canada Pension Plan Disability was also the target of damages wanting to be mitigated in this form of social insurance. Kugliari versus White, Ontario Court of Appeal, 1998. This was not permitted because of Bradburn. So that precedent I keep talking about is important. 4, Sarvanis, Supreme Court of Canada, 2002, had the federal government try to overturn Bradburn. The Department of Justice argued that the Canada Pension Plan Disability was a pension, was barred because of Crown Liabilities and Proceedings Act Section 9 applied. This was doomed from the start. I put in brackets Kugliari, 1998, Ontario Court of Appeal, but that didn't stop the Crown from trying to mitigate its damages through a novel argument. It's not novel. It's insane and dishonest. They ought to know the rules. H. To recap, to the ignorant of the fact that the insurance and charity are allowed to be paid in addition to tort damages, it's called, instead of the Bradburn rule, sometimes it's called the insurance and charity exception rule. And sometimes it's called the insurance exception rule. People wanting to save money have invested a lot of time and effort into attacking this long-standing legal rule that you can legally and equitably get tort damages to replace the tort loss plus non-indemnity insurance, pensions, and charity because of the Bradburn rule. The federal government took this to a whole new scale in Manouche Federal Court 2012, in that it affected thousands of disabled and service veterans who had to be made whole in contract for their loss, as the non-indemnity SISIP policy was to call the pension capital payment an income payment, which was clearly false, as it was not earned with current service. It is paid based on the event that caused economic damages, and I put in brackets capital. So do you see how the Bradburn rule is vital and precedent is important? Okay, so instead of simply allowing the precedent to happen and people get used to the law and everybody's happy, oh no, the people who have to pay are not happy, and they try to invent bullshit to try to make the disabled person get less money. Basically, it's a form of discrimination, I would say. Now, this next one is about current events, but I'll relate it to our stuff as well. Trump, that bastard again, because I don't like Trump. Well, you could say I hate the fucker. The cult of Trump has no bounds. Just yesterday, the Republican acting Speaker in the House of Representatives struck the words of a Democratic congressman because he spoke about the facts surrounding Donald Trump's many criminal cases. The words were spoken in a debate where anything can go, usually due to the parliamentary privilege. Democracy requires robust debate. The Republican snowflakes did not want to hear disparaging words about der Fuhrer. Another point I might not make, but for the Unified Reich video that was posted by Trump the other day on social media, the Truth Social. Then I saw that the Republican Ohio government took the current president, Joe Biden, off the ballot for November of 2024. This was not allowed when Trump was taken off the ballot for insurrection by Colorado, so what makes Ohio think that they can steal the election for Trump? He's likely to be in jail, at least I hope so, after the election interference case in New York having gone disastrously for him. For example, for those not following this train wreck, a Trump witness sank his case at the end of the trial by trying to cover up the Michael Cohen damning testimony. The judge even had to clear the courtroom when the Trump witness tried to intimidate the judge. I think the jury of Trump's peers will convict as number one, he signed checks to reimburse Cohen. Just to be clear, if you pay someone a lawyer legal fees, you don't sign checks to reimburse him for another expense. You pay him for his services that you agreed to in a contract. If they have a legal services contract, produce the contract that you signed with him that said, I will give you this much money under a retainer agreement. As far as I know, none of that happened. 2, he claimed the payments were legal expenses, but like tort damages, the payment was meant to reimburse Cohen and not compensate him for the time as a lawyer. 3, he did not. He did this to make sure that a story did not come out in 2016 during the election, committing fraud on the United States of America, as many voters would not have voted for him if the story that Cohen got reimbursed for got out. Furthermore, I recall the Republican snowflakes because they profess free speech when arguing that Trump ought to be able to use his constitutional right to free speech to attack witnesses in spite of a gag order put in place by the court to protect the witnesses and the jurors. Free speech has limits, like not being able to yell fire in a crowded theater if there's no fire, as it might cause harm to others. See, people seem to believe, like in Canada, we have freedom of expression, but in the United States, they have freedom of speech. But it's not unconditional. There are conditions. And if you abuse it, if you put somebody else's safety at risk, you don't have the right to just say anything you want about things. Now, I would say, based on my experience and my reading, normally, defamation and libel might be the civil remedies that you might have to go after someone who has done you harm. But in the case of this trial, Trump has a cult, and if he speaks up against somebody, his cultists might attack them, just like what happened to Nancy Pelosi's husband. Okay, enough of that stuff. I mean, it got me upset, but I thought I could make a teaching point of it, sort of. 3, getting back to Canada, sort of. I saw a term in the news about Trump using Cohen as a front man. And I thought this applies very good to the insurance situation with the way that employers use the insurer, and I should have put air quotes or quotes around that because they aren't the insurer, they're actually only administering the policy for the employer who acts as the underwriter, as the front man or agent. I have been saying this forever, yet they actually put it into the policy that neither are an agent of the other. Now, I'll read that out later because it's in the SISIP policy. I think they protest too much by including the term. That is exactly the legal relationship between the Crown and Manulife. Manulife was not sued, for example, in contract. The people who can be sued are the signers of the contract, the parties to the contract. Something McInnes Cooper knew well, as Manulife was never the target of the lawsuit. Let me bring back the first point. Okay, so I'll show how this is relevant. At least I hope I will. That's what I'm trying to do. Educate the viewer to show that what I'm saying is not bullshit and to show that the Crown is in the wrong. A. Gibson versus Sun Life, Ontario Superior Court, 1984. Sun Life was the agent and Canada was the insurer. Therefore, the case should have been Gibson versus Her Majesty the Queen. But they're misleading the court, and getting away with it makes the justice system look stupid when the facts come out. The person was working for the Canada Revenue Agency before becoming disabled in an automobile accident. Now that might be a coincidence, but on to the second case I'm talking about. B. Sun Life versus Ryan, Nova Scotia Superior Court, 2003. Once again, it was Canada that was suing Ryan, not Sun Life. In fact, it was Canada Revenue Agency, because that was who the person worked for. Is this a coincidence? Seems too strange to be a coincidence for me that Canada Revenue Agency was the same agency suing or getting sued. They are all about raising taxes, and I put in brackets money, so they might be greedy. I don't know. They should prove that this wasn't a coincidence, because there's a pattern. Brian, Nova Scotia Superior Court, 2012. Another pattern is Nova Scotia being the common denominator. I spoke to the McKennis Cooper lawyer representing Canada, who told me they told the judge that it was Canada that needed to be sued and not national insurance, but the judge refused to accept reality. Bruce Bryan, I spoke to him at length in the past, was a Ports Canada policeman in Nova Scotia who became disabled and was getting the Public Service Management Insurance Policy, PSMIP, which is one of the 4 federal long-term disability plans. That one, it covers non-unionized public servants, managers, and members of Parliament. This is the third example of a case gone wrong. Too much to be a coincidence, I think. It's a deliberate cover-up, perhaps, a word I do not like to use, but it could be a conspiracy, which is Section 465 of the Criminal Code. D. What do I think they will say to the defense of this cover-up? Everybody does it. That is a failed defense used in the Dennis Manouche 2012 case on pension clawbacks. The fact that many people break the law does not give you the right to break the law. Caveat, I wish I didn't have these strange thoughts, but you know, if someone said to me and I was doing the same thing as somebody else that I broke the law, I'd say, listen, boys, it's against the law, I know that now, but everybody does it, and therefore the lack of enforcement should mitigate my penalty, but I wouldn't argue I shouldn't get punished, right? I often use this analogy. Number one, you are driving along the highway, going 100 kilometers an hour and 100 kilometers per hour speed limit. Point number two, other cars, drivers whiz past you going far in excess of the speed limit, which you observe. 3, so you decide, well, if they're doing it, I will. You speed up. Then you get red lights in the mirror and a speeding ticket ensues. 5, telling the cop everybody else was going fast too does not relieve you of the individual responsibility for obeying the law. You have to accept the ticket. Now, I've used that analogy many times, and I think it's a very good one. To argue that everybody does it is a weak deflection. Now, I had this done, and then later, I think I went back, and I did have a 4th point about reimbursement agreements. Now, A. Canadian Forces Ombudsman in 2003, in his report about the Pension Act pension being an unfair deduction from the Service Income Support Insurance Plan, stated that veterans weren't too happy about having to sign a reimbursement agreement with Maritime Life at the time. Now, what they said was, oh, we don't have a problem with that because the veteran signed it. So later, I'll probably get into that post too, I called the Canadian Office of the Veterans Ombudsman, and I spoke to them, and I'll give you the gist of that later. B. Sun Life versus Ryan, Nova Scotia Supreme Court, 2003, mentions them. Links to subrogation, a term mentioned in the SISIP policy, but it has no real application to SISIP, as my understanding of subrogation is that the insurer sues somebody in your name so that they get indemnified, paid back, for the insurance payment they made to you. So it's like passing the buck or possibly putting the cost to the target, to the person who ought to pay it. So that's what subrogation is. Now what they're doing is basically saying if you get any money at all from Canada Pension Plan or the Canadian Forces Pension or this or that or the other thing, you got to pay us back. But that's not really what subrogation is, and that's why in the Sun Life case they were talking about this is really a reimbursement agreement. C. Rapino, Quebec something, QCCS 2003 also mentions this topic. D. I linked it to the irrevocable consent form that the Canada Pension Plan Disability requires. I said the irrevocable consent forms for the Canada Pension Plan Disability is based on this premise that you have to reimburse somebody, that you have a debt to somebody, when that debt is not legally possible. Why isn't it possible? 1. Privative contract. That's a principle of contract law. The Canada Pension Plan is not a party to the long-term disability contract, so they cannot ask for your Canada Pension Plan disability to pay the alleged debt. They just can't do it. It's none of their business. 2. Canada Pension Plan is property. Pensions are always property. They're not income, they're property. They might appear to be income to the uninformed or the ignorant, but they are not income, they are legally property. 3. Due process of the law is supposed to take place in any alleged debt before collection, but these people do not follow the due process system. I didn't put that in there, but due processes. Look, you're supposed to get notice. You're supposed to have a hearing where you have your voice supposed to be heard, and then you're supposed to have an independent judge. None of that happens. Okay. So then, because I was talking about the reimbursement agreement, I looked up the Sun Life versus Ryan case, and I put in there paragraph number 17. In March 1996, a reimbursement questionnaire was sent to Ms. Ryan, and a copy was returned to Sun Life, signed by Ms. Ryan, and witnessed by her counsel at the time. The questionnaire contained the following sentence. Under the terms of your group policy, and I don't know why the numbering there is confusing me a bit. Under the terms of your group policy, any amount Sun Life pays to you under the group policy as a result of injuries, your injuries are refundable out of any compensation that you may have received from the party responsible for your injuries. Now, doesn't that sound like the subrogation thing? But the thing is, for a true subrogation case to happen, Sun Life is supposed to sue the other party. They don't have to be a reimbursement by Ryan, because they are the ones who gets the money, because they sue in the injured party's name. Why didn't they bring that up? That just occurred to me. I didn't put a footnote in there about it. Now, it is the position of counsel for Ms. Ryan that this was signed under duress. Now, many times I have looked at cases, and even though I'm not a lawyer, I footnote them, my points. So point number 1, Sun Life policy 12,500G is the policy for the federal government unionized public servants. It is a non-indemnity policy, so there is no right to subrogate in the first place, and it is not supposed to be allowed to claw back, and nor can it be clawed back. If the payments were allowed to interact, contravening the Bradburn rule, then the judge would have to say who gets to deduct who. should I lower the damages in tort to give the wrongdoer an advantage over the disabled victim that the wrongdoer created? Or should I ignore the earned benefits, any earned benefits as per the precedent set in Borelli, Ontario Court of Appeal, 1973? See, the judges in these cases are turning a blind eye to past precedents when they seem to want to have a verdict that will favor the insurers and the government of Canada. Okay, the part about duress. I put the second footnote. I said, obviously, this case wants to deduct tort damages. SISIP and VAC claims it can do this under Section 24A, 44A of the policy, and the Veterans Wellbeing Act Regulation, Section 22. However, these are two different fields of law. A contract of insurance is not available to a tort wrongdoer. Non-indemnity and contributory insurances do not own the legal right to clawback, the British Law Reform Report, I put in brackets. So they attacked this legal shortcomings in Glynn, Ontario Superior Court, 1984, to make a new precedent in the partial indemnity that was created. Precedent is only overturned rarely, or it would not become a binding precedent in the first place. Okay, you're supposed to have a good reason to have a precedent. Okay, I put two footnotes to the first paragraph, and then I put a second one towards the consent. So I said it was probably under duress. This is probably true because the Canadian Force Ombudsman report in 2003 and the Manus Federal Court 2012 had duress mentioned in a roundabout manner. Any consent that has to be freely given and fully informed. Saying if you don't sign this reimbursement agreement, you're not going to get your insurance is clear duress and possibly something criminal like fraud. Now, before I go on to the other post, I'll go through this case, Bradburn versus Great Western Railway. I found a British law repository, and I took a picture of it. Instead of going through the whole case, they had a summary there. And they said the plaintiff had received a sum of money from a private insurer to compensate him. I don't agree with them using the word compensate, but I got no choice but to list it off. That's what they said. For lost income as a result of an accident caused by the negligence of the defendant. Held. So they give a summary about what the dispute was, and then they say what was the verdict. Held. He was entitled to full damages as well as the payment from the insurer. And then they put a quote there from the judge. I think there would be no justice or principle in setting off an amount for which the plaintiff has entitled himself to under a contract of insurance, such as any prudent man would make on the principle of, say, laying away for a raining day. He pays the premium upon a contract which, if he meets with an accident, entitles him to receive a sum of money. And I think it ought not, upon any principle of justice, to be deducted from the amount of damages proved to have been sustained by him through the negligence of the defendants. Perfectly reasonable. Very logical. Now, the Borelli case in 1973, I got a picture put there, have a look at it, and the judge said, well, I'll start at the top. However, I think it's safe to presume in present society that such benefits are included in the wages that the employee received and for which he must work, rather than requiring proof of such facts in every case. It is well known that the determination of a remuneration to be paid to employees, fringe benefits are considered in arriving at a total wage benefit package. And the amount of a weekly salary or wage is dependent on the cost of the totality of the benefits. Perfectly logical, ain't it? I cannot conclude that there is any equitable principle which would allow a tortfeasor, which is wrongdoer, to obtain the advantage of any benefits earned by the person who has been injured. So basically, it's about morals. It's evil to have the person who put someone in a wheelchair save money because the person in the wheelchair had insurance. It's downright despicable. Now, another case I was quoting, I might have mentioned, I might not have mentioned, the Salts, British Columbia Court of Appeal case in 2006. That a trial judge awarded damages to the respondent for past wage loss, $225,000, and lost earnings capacity, $600,000. Can't see the difference well. Anyway, he deducted the Veterans Affairs pension from the award of damages for past wage loss, but did not deduct the superannuation pension. The trial judge said at paragraph 172, the superannuation pension is a pension that the plaintiff contributed to and is entitled to as a result of her years of service with the Royal Canadian Mounted Police. The fact is that if she had worked for 35 years, she would have contributed more to her pension and it would have been much larger. She also contributed to the Great West Life Insurance Disability Plan. Payments received from these sources are collateral benefits that should not be taken into account when calculating her past and future wage losses. A tortfeasor should not receive the benefit of the plaintiff's foresight in contributing to insurance and pension plans. Thus, the monies paid and payable under the Veterans Affairs pension are the only monies that should be deducted from the plaintiff's wage loss claim. Now, if in the unlikely event that anybody who is aware of the Dennis Manews class action looks at this and says, what the fuck was that judge smoking? He got it backwards. Nope. This is exactly the problem that I was discussing before. Should the people who hurt the other person save money by taking into account the Pension Act pension? Or should the Veterans Affairs Department save money because they take the damages into account? So the judge made a decision to bring up the Pension Act pension and say you can't be compensated twice for the same event. In principle, that is correct. In law, the judge broke several federal statutes. Statutory Instruments Act, Section 16, requires judges to take judicial notice of federal law. Then there's two laws in the Pension Act, two sections of the Pension Act that the judge promptly ignored when he let British Columbia save money because the nation was paying the person a pension. Section 30 of the Pension Act says that no creditor can take the Pension Act directly or indirectly. So by taking the money into account, the judge directly violated the Pension Act Section 30. Then there's another conflict created by Section 25 of the Pension Act, which says that if you get involved in an event and you're in the Canadian Forces, and you then sue the person that hurt you, and you also get a pension, then the Government of Canada will convert the lump sum damages into a monthly payment and promptly take it off your pension. Now that is another law that seems reasonable on the surface. But the problem is, again, who would take precedent? Who has priority? Is it the province of BC that should save at this veteran's expense? Or is it the nation that had the person serve Canada as a Royal Canadian Mounted Police save at this disabled veteran's case when the other fucking RCMP members are the ones who caused her goddamn injury? Now this kind of stuff makes me upset because these people are looking at something and trying to decide which one should save when they should fucking butt out when they're the one who caused the injury in the first goddamn place. I hope you agree because I think I'm being very logical here. Now, if it was somebody else who caused the injury, it might be a little bit different. But all of the things that I have explained so far, I think, are self-evident. I even spoke to the lawyer representing Nancy Wilson Schultz, and I believe I might have even spoken to her, because this shouldn't have happened to her. Now, I don't want to be here all night, so I'm going to go through my second post I made, and I'm not going to get into the lawyer's letter. That's there. You can read it for yourself if you care to. Now, what happened was I was looking through this post, and I was talking about reimbursement agreements, and I was talking to the Veterans Ombudsman office a couple of weeks ago, I think, and I thought, you know, if they look into things, they might want to take this point I'm making into account. So I made the mistake of calling him. Now, the guy was pretty good to talk to, but a couple of things niggled me. Tried to say, well, this is SISIP, you're calling the Veterans Ombudsman, you should call the Department of National Defense Ombudsman. And I said, hey, don't give me that crap. There's only one crown. And whether it's the Department of National Defense or the Department of Veterans Affairs, you're still part of the government. Okay? So I think you ought to do a joint investigation. But even if you did a singular investigation, well, the Department of National Defense Service Income Support Insurance Plan forms 83.33% of the income replacement benefit, which is a Veterans Affairs program. According to the program arrangement, section 3.2.1, I told them, SISIP Financial Services will provide income replacement for anybody who gets medical release. So, therefore, it's the Office of the Veterans Ombudsman who can look into this. Now, the issue I wanted to bring up with them was the illegality of these reimbursement agreements. Okay? So, am I ever going to get there? Okay, so here it is. I made a mistake of calling the Office of the Veterans Ombudsman. I was commenting on the pictures from the first post of the day when I thought maybe I ought to call the Canadian Forces or the Veterans Ombudsman to ask them to examine the duress mentioned in the Manus Federal Court 2012 case if they ever do that joint investigation into SISIP Policy 91102, forming 83.33% of the income replacement benefit. Now, if I was just typing this stuff for me, I would not go into such excruciating detail as I'm doing here, but in case there's a new reader for this stuff, I'm hoping that they won't be confused. So the agent was okay to talk to, and the cell was not giving good call quality, but he seemed to want to divert the call to the Canadian Forces Ombudsman because SISIP was a Department of National Defense program. Here is the gist of why I said no. Number one, the Department of National Defense and Veterans Affairs Canada are both Crown departments. Number two, the Department of National Defense, Veterans Affairs Canada, and SISIP Financial Services signed a program arrangement in 2006. Number three, the income replacement benefits made up mostly of the SISIP long-term disability for medically releasing veterans. 4, income replacement benefit is a Veterans Affairs Canada program, not a Department of National Defense program, but both are Crown programs. 5, tell the agent that I spoke to last to look at my observation post group and think about the consent that which must be fully informed and freely given to be valid. That's what I want them to look into, to review their decision in 2003 to say it was okay that the signature was there. That caveat, normally that's the way it works. If your signature's there, too bad. But really, your signature there could be there because someone didn't inform you of the full details. Or they could have put pressure on you to sign it. So simply saying your signature's there and saying too bad, so sad, that's not good enough. It's not. 6, tell the agent about the Canadian Bar Association paper in 2010 and the lack of legal consideration making the agreement void. Okay, so the government says there's a reimbursement agreement, but no consideration was paid. Tell the agent about Rapino, QCCS 2003, the Canadian Forces Ombudsman report part about the reimbursement agreement, and the Manus Federal Court 2012 point about duress being present, voiding any such consent. Number 8, tell the agent that a simple signature on an agreement is not acceptable, unlike what the Canadian Forces 2003 report stated. Consent must be fully informed and freely given. For example, no coercion. Tell the agent. Number 9, I wanted to bring out the fact that the Department of National Defense Insurance has no legal compulsion to participate in rehabilitation, unlike Veterans Affairs income replacement benefit, but he was too busy. Said he had another call, so I didn't feel like arguing, so I hung up on him. My point here is that you have to get the insurance you bought without conditions such as rehabilitation. The same is true for damages. Okay, it's a very simple thing. You harm someone, you don't have the right to put conditions on your payment to make them whole. That's tort damages. Now, in insurance, if you take the premiums as the consideration for paying insurance, if the event happens, you don't get to say, I'm sorry, but unless you participate in our rehabilitation program, I'm not giving you any money. In fact, this is another form of duress. Now, the thing is, here's what I think happened. My professional, my expert opinion. Something like 96% of disabled veterans in the SISIP program are in the rehabilitation program. Veterans Affairs Canada looked at that when they were creating the income replacement benefit in 2006. It used to be the ELB, earnings loss benefit, but I'll say income replacement benefit, that's the new name. And they said, well, this is mandatory. But you see, it's not mandatory. I asked a Manulife agent, Christopher Anderson, directly if this was mandatory. He told me no, because you can't put a condition like that on a person who bought insurance. You just can't. Not legally possible. But to the casual observer, it appears to be mandatory. And the Veterans Affairs people designed a system that was copied after SISIP, so they put into place what they thought was in place in the Department of National Defense. Some people might say, well, who cares? Well, it has to do with freedom. It has to do with getting what you paid for. It has to do with being respected and getting the things that you paid for. Because if you think about clawbacks, could be this, it could be that. You could be clawing back to Canada Pension Plan or the Canadian Forces Pension or the Pension Act pension. What they're saying to you is, we want your premium, but we don't want to pay you the insurance. And this is a violation of insurance law. You are not allowed to take the premium and then not pay the insurance if the risk happens. It just is not fair. It is not legal. So listen, that's long enough for tonight. I think it's 42 minutes according to the clock I'm looking at here. And I will get around to, I hope, trying to find a lawyer. I'm just trying to figure out the best plan, how to approach it. Thanks for watching. I'll see you next week.